Hello everyone, I'm Gemma. I'm a second six family law pupil at Spire Barristers, and joining me is Chloe, my co-pupil. This webinar is going to discuss unregulated and unregistered placements. If I can just start with some housekeeping rules. If everyone could just keep themselves on mute during the presentation, this just helps make sure there's no background noise. We do have quite a lot to get through today, so we might only have time for a limited number of questions at the end. So I think the best way to go about this is during the presentation, if any questions come to mind, if you could just put this in the chat bar below, and me and Chloe will keep an eye on this throughout, and hopefully we'll get to answer a few questions at the end. So on the slide now, you can see the agenda for what we're going to cover today, and I'll pass over now to Chloe, who will begin with the differences on unregulated and unregistered placements. Thank you.
Thanks, Gemma. Hi, everyone. So as Gemma said, I'll begin just discussing the differences between the unregulated and unregistered provisions. Now, there's a considerable degree of confusion and uncertainty about whether and in what circumstances a type of provision should be defined as unregulated or unregistered. Unregulated provision is allowed in law. This is when children who are usually over the age of 16 need some support to live independently rather than needing full-time care. Ofsted do not currently regulate this type of provision. It's for local authorities as corporate parents to make sure any placements are safe and suitable for their child to live in. Really, what it is a stepping stone to independence, and only ever when it's in the child's best interests. For example, a few indicators that the care you're providing is regulated would include that the young people are able to leave the premises without permission from a provider, and the young people have full control over the finances, and possibly that there are no sanctions or policies for the young people, and apart from normal rules and legal sanctions that would be imposed to an adult. So there is a clear difference between simply providing support to children compared to providing care. And for many children, this is the right choice for them to be in a provision that allows them to live independently. Some children don't want to live with foster parents or be in a children's home and want some independence and are able to have that. And there have been calls for reforms for these types of placements to be regulated by Ofsted because of a number of concerns. And I'm sure you're all aware of some of them, but some are in relation to children's safety. Now, we do cover this a little later on in the presentation when we go through what reforms are expected to come in. Now, in comparison, an unregistered provision is when a child who is being provided with some form of care is living somewhere that is not registered with Ofsted. And the key difference here is care. When the placement's not registered, but the child is being provided with this care, this makes a placement illegal. And once a provider delivers this care element as well as the accommodation, they then must register as a children's home. In many circumstances, staff may not realise that they need to register with Ofsted, and this can happen and does tend to happen when a supported living provider has extended what they do without recognising that they've crossed the line into providing care. It is also common in short-term arrangements or crisis responses. For example, when a placement for a child needs to be found quickly. But it's not always the case, and some providers are willfully not registering. It's important that as local authorities you get to know which providers are not registered so that you can make the best decisions about where to place children in your care. It's obviously not right that some of the most vulnerable children with challenging needs are often living in places with limited oversight, or where the people caring for them may be not suitable or skilled enough to meet their complex needs. Care is not just about the age of the child, although as we all know that is a factor, but care is about a child's vulnerability and the level of help that they need. If a child needs care and support because of their age or because of vulnerability or because of their extremely complex needs or behaviours, then the service they're getting needs to be registered. So I'm going to now talk you through the use of unregulated and unregistered provision. And the table on the slide shows the reasons given by just 4 different local authorities as to why they use unregulated placements. And there is a full table in the Department for Education Research, which compares 22 different local authorities. And the link to this research is on the slide, and the slide will be sent around after the presentation, so you can access that. Of all the local authorities involved in this research, they stated that they had at some point used unregulated provision and use it quite regularly. For most local authorities, this provision was being used as a positive choice to support young people, usually aged 16 or 17, to transition to independence. But the extent to which this is used does vary depending on whether local authorities have policies in place that encourage all children in care to remain within a children's home or foster care until the age of 18. And several of the local authorities use existing unregulated providers with sort of bespoke packages designed to cater for young people with multiple issues. And the list of issues is extensive, but just to give you some examples, it may be mental health issues that children suffer from. Maybe they have a history of assaulting staff, fire setting, and self-harming, and all of those issues. This is often in a context of a placement breakdown, and the local authorities have to step in and come up with a package to help this child and for this child to be placed. And we do know that local authorities are facing hard times and having to make these tough decisions. And many children are difficult to place in a registered provision. So what seems to be happening is children are being placed in the unregulated, unregistered setting as a short-term measure. The number of children in care aged 16 or 17 placed in unregulated settings increased from 2,900 in 2009 to 6,100 in 2019. So we need to look at why this is happening. The growth in the use of unregulated and unregistered provision for children with complex needs and challenging behaviour seems to really be driven by 2 factors. The first is that there's such a demand for these registered places, and that's currently outstripping the supply. In the report I've already spoken about by the Department for Education, the local authorities that were interviewed, of every single one of those, they highlighted that this is a key issue, and all reported similar experiences. This trend is also being noted by the Independent Children's Homes Association. In their report of 2018, they stated that children's homes were receiving at least 500 referrals a month, and supply was nowhere near as quick enough. It wasn't expanding as quick enough to meet that level of demand. And this confirmed just by the statistic I've shown you on the screen. The second factor is that registered children's homes are becoming increasingly reluctant to accept children with the complex needs and challenging behaviours that I've outlined. And this is something that I'm sure all local authorities here are more, aware of. Where young people in unregulated settings have these complex needs, this appears to often be a crisis care because of placement breakdowns. And because the local authorities are finding it difficult to place young people in these registered provisions, that is the reason why you're having to turn to alternatives, at least temporarily.
Section 1 of the Care Standards Act 2000 defines an establishment as a children's home if it provides care and accommodation wholly or mainly for children. And if a home falls within this definition and it's not registered as a children's home and a child is placed at the home, this then becomes an unlawful placement because it's not regulated. And to register these placements as children's homes, the establishment must meet a series of requirements, and these are set out in the Act of 2000, also the Care Standards Act regulations, and the 2015 Children's Home regulations. I'm not going to go through all the regulations because there's many, and you can look at these acts if you want to see them. However, one of the most important requirements to register a children's home is that it must be registered with Ofsted. And what we're seeing from the research from the Secure Welfare Coordination Unit and also the Department for Education is that many children who are living in these unregulated settings have been referred to secure care, and they typically have complex needs with often a history of multiple placement breakdowns. And this touches on some of the things that Chloe's just mentioned. As she said, registered providers often are reluctant to accommodate these children, and this takes us on to the recent case of Reassess, where it looked at this matter. So the case of Reassess, I think this was in March this year, it's a very recent case, and it concerned a 15-year-old girl who, for the purpose of the hearing, she chose to go by the name of Samantha. And she was subject to an ICO and an order authorising the local authority to deprive her of her liberty. She was living as the only young person in a holiday cottage, which had been rented by the local authority solely for the purposes of accommodating her. And she was living with, and she was supervised on a day-to-day basis by 3 members of staff who were employed by an independent care agency. Now, this placement in the holiday cottage was not registered as a children's home, and therefore it was unregulated by Ofsted, and it was an unlawful placement. And this is quite often the situation for young people that need to be placed in secure homes. As Chloe's mentioned, there's simply more demand for these placements than there are placements available. And this leads local authorities to have to make these decisions and place these children in holiday cottages, caravans, B&Bs. They're just a few examples, with secure staff at all times. But what this case confirmed is that accommodation like this, where a child is placed in one of these temporary homes and is being looked after by secure staff, it does fall within the definition of a children's home in the Care Standards Act 2000. And so Mr. Justice Cobb in the case provided guidance that whoever is providing this care, so in that case it was the local authority, they must take the steps urgently to get the home registered with Ofsted. And I'll touch on this more later, but I think there has been some confusion amongst local authority lawyers, social workers, and all of us that work within the family courts, that placements, if they're only temporary, that they can't be registered with Ofsted. However, it is confirmed by Ofsted that's not the case, and these placements can be registered, and they should be registered, and therefore they won't be unregulated anymore and not unlawful. So this was the case of Reassess. Chloe's now going to discuss another recent case of RET.
Thanks, Gemma. So RET is a case from 2018. It's a highly noteworthy case as it was the first time that the Court of Appeal really looked at the right of consent within Article 5 of the European Convention on Human Rights. Now this again concerned a placement of a 15-year-old girl who was in an unregistered provision. And the appeal related to the exercise of the High Court's inherent jurisdiction to make orders akin to secure accommodation orders under Section 25 of the Children Act, where the statutory system has no capacity. And an order under Section 25 could only be made in respect of a unit registered as a secure children's home and approved. The issue in this case was not whether the jurisdiction to make such orders existed, was the manner in which that jurisdiction was to be exercised in circumstances where the child was 15 years old, she was GILIC competent, and she had consented to the proposed care regime. Ultimately, the question came down to whether a child's consent invalidated the court's power to make such an order. However, I wanted to really highlight this case because at the commencement of his judgment in Reassess, the President, Sir Andrew McFarlane, expressed concerns stemming from the official figures and anecdotal evidence of advocates and judges as to the growing disparity between the huge demand for secure accommodation places and the small number of places available. And this is still a problem now, and I'm sure will still be a problem for some time.
It is recognised that placing a child in an unregistered children... Sorry about that. It's recognised that placing a child in these unregistered children's home is often unavoidable for you as local authorities. As we've said, there's just simply not enough beds available in these secure homes, and sometimes you have no option but to accommodate children in this way, and it's urgent and you see it as a temporary measure. However, the urgency of the situation doesn't make it acceptable, and there are some steps that local authorities can do to try and reduce the amount of times this happens. The practice guidance and the case of Reassess that I discussed highlighted that the local authority should take immediate steps to register these placements with Ofsted. So if you have a case where you're having to place a child in a cottage or a caravan, like in the case of Reassess, and it's not registered, you really need to go about applying to get this registered. Even if it's an urgent and what you see as a temporary measure, it's really important to take that step. It was recognised in the case of Reassess that by the time the registration goes through, that the child may no longer be placed there, but don't see that as an excuse, so to say, not to register them. It's really important you still make the application. So that was taking all the steps you can to make sure it's not unregistered. The second thing that local authorities have been suggested to do is continue the searches, of course, for a registered children's home in a secure unit if that's necessary. And you can exercise your powers under the it's Regulation 10 of the Children Regulations 1991, the Secure Accommodation Regulations, and this allows the local authority to place a child in a secure placement for 72 hours maximum, and you will need to urgently bring this back to court to get the authorisation of the courts, but you can use that power in the meantime, so I'm sure you're all aware of that anyway, but that's also a recommendation. The third recommendation is don't stop searching, be relentless with this every single day, make the applications, inquiries to the National Secure Welfare Coordination Unit, referrals to independent agencies offering residential care nationwide. You can also make inquiries with other local authorities and see if they've got any placements available. In the case of Reassess, the local authority did all these things, and Mr. Justice Cobb set out all the steps the local authority had taken, and they were making these inquiries every single day since the child was placed there. And I think that's just a way to protect yourselves as local authorities, so that when it does get to court, you're not too heavily criticised, because there is understanding that to an extent it's outside your control. You can't control what places are available, but what you can control is what you're doing about finding a place. And if a statement is ordered, for example, to say the local authority need to set out what they've done to find the child a registered placement, then you'll be able to be confident that you have taken all the steps necessary. So I'd really recommend, I know there's so much work for you to do, but really every single day you need to be making these referrals, because from my understanding, it is done on a day-by-day basis that the placements look at this and see who they can offer a placement to that day. Another thing that has been, a local authority themselves actually put this forward as what they had been doing, and this was in the Department of Education research paper. They said that to try and avoid having to use the unregulated and unregistered provisions, they have expanded their own provisions, and they've been offering additional support to residential homes, also looking out for alternative placements or using out-of-hours foster care, carers. And this is just to try and make sure the placement doesn't break down in the first place, and making sure the child doesn't have to be moved to an unregulated placement. I know often it is totally unavoidable, but if it can be done and if the resources are there to expand, then this should also be a step that should be taken by the local authorities where possible. Obviously, I do understand resources are limited, so it's a management's decision, I suppose, to see what steps can be taken. Moving on, there is reform should come, hopefully. That this is it's a government issue, really, that they need to increase the provisions, the guidance. Ofsted as well need to get involved, and there has been a government consultation that's been produced. I think it was just finished on the 3rd of this month. The links are here, so when you get the presentation, you can click on that and have a look. But in summary, what it proposes is to ban using the independent and the semi-independent provisions for under 16-year-olds that Chloe discussed in the beginning of this presentation. Also to introduce national quality standards to ensure that independent reviewing officers represent the young people's interests, a requirement that local authorities and police forces have to communicate with each other, and also new legal powers for Ofsted to take powers against illegal providers. So at this time, we don't know if all these proposals will come into force or when they'll come into force, but it's definitely something to keep an eye out for later in this year. Also, Ofsted, they've increased their inspections. They have the power to look at the decisions local authorities are making as part of their inspections. They can look at the children's services departments, and this is so they know how the local authorities are making their decisions about where a child should live, and it just gives scrutiny to you, local authorities. So that's why I say, make sure you're recording everything you're doing day by day. Keep a diary, for example, of who's doing what searches have been made that day, so that if Ofsted do come and investigate, you've secured yourself from scrutiny there. And I think that's all on children's homes now, and Chloe's going to speak about connected persons and foster carers.
Thanks, Gemma. So as most, or if not all, local authorities will be aware, the Adoption and Children Coronavirus Amendment Regulations 2020 came into force in April and are not due to expire until the 25th of September. And these regulations make some significant, whilst temporary, changes. And I'll just outline some of the changes which impact the regulations in relation to unregulated placements. So starting with the unregulated placements with connected persons, Regulation 24 of the Care Planning Placement and Review Regulations 2010 provides that where the local authority is satisfied that an immediate placement with a family friend, family member or other connected person is the most appropriate placement for the child, notwithstanding that the proposed carers are not approved as foster carers, the carers can have temporary approval for a period of up to 16 weeks, provided that an assessment of their suitability under the regulation has taken place. The regulations have amended that maximum period of temporary approval from that 16 weeks to 24 weeks, and that was amended under Regulation 8 of the Amendment Regulations. As you'll be aware, if a child is placed with a connected person who's not approved under the regulation, the placement is unlawful, and any decision to continue with the placement in breach of the regulations should be taken by a senior manager within the local authority. And the reasons for the decision to continue with any unlawful placement should be recorded clearly with the risks of the placement identified and case-specific support and monitoring arrangements detailed. The need for the placement and the reasons why it remains unlawful should also be kept under frequent review, and a plan to approve or register the placement or for the child to be moved to a lawful placement as soon as possible must be set out and followed. The child's independent reviewing officer should always be consulted about the plan and should ensure that the placement is kept under review. I'm just going to give you an example. I'm sure you're all aware of how this works in practice. So if a child is placed with a connected person under Regulation 24, whose assessment cannot be completed and presented to a fostering panel, and this may be because of the absence of a health report, the regulation requires that if a carer has not been approved fully as a foster carer after 16 weeks usually, but now 24 weeks, the placement must be terminated and other arrangements made for the child's accommodation. And failure to comply with these regulations makes that placement unlawful. There is an additional amendment from the coronavirus regulations, which now means temporary approval as a foster carer under Regulation 24 has also been expanded to allow any person, not only connected persons, to be approved. So in relation to unregulated placements with local authority foster carers, an emergency placement with an approved foster carer can now last 24 weeks rather than 6 days. Where a child is placed with a foster carer, the Care Planning Placement and Review Regulations 2010 and the Foster Regulations 2011 determine the way in which a placement should be managed. If a child is placed with a foster carer where the placement's not in accordance with the terms of approval, then the placement is unlawful. For example, a child needs a foster placement that meets their specific needs, but there are no available vacancies, then you may have a carer willing to take the child, but in doing so, the placement of the child would exceed their approved number of placements or possibly be outside their approved age range. Regulation 23 allowed for such a placement only for a maximum of 6 working days, after which the placement must be terminated unless the terms of approval were amended and agreed. However, the coronavirus regulations have amended this from just 6 working days to 24 weeks, as I said at the start. This is a very significant extension. We just want to say thank you all so much for joining us in this presentation today. We do have a little bit of time for some questions, so if you can pop it into the group chat, we'll try and answer a few. Thank you all. Oh, sorry, and just to let everyone know, I know it was mentioned in the group chat as well, the presentation will be shared to everyone who's signed up, and we'll also send the slides with the links and some additional information in for you all. Hopefully there will be some more training sessions in the next few weeks, so